Okay, we are back. It's been 24 hours. Nate, how are you doing in the 24 hours since our last episode?
I am doing okay. Things have gotten interesting. Like this morning, like seems like the world is crashing again. Do you guys feel like you get like a year's worth of news in like the past 24 hours? Prince has been arrested. Another prince has been arrested. Then we got the tariffs being taken down. It's like, what the hell's going on? This is like 24 hours now.
Well, this is just reminding me of 2025. Remember, ever since Trump got elected, it was like...
Yes. We live in the best timeline ever at this point. It just won't stop.
And now we got to fight the warmth of collectivism in New York. So yes. It's like everything is just going crazy.
By the way, on that note, Nate and I had a laid back law yesterday. Some of you may not realize that we've been going every Thursday and Friday. And if you want to find out about the worth of collectivism, one of our main subjects yesterday was the illustrious communist, I call him communist, Mayor Mandami. Nate thinks he's a spiffy, nice guy, and I shouldn't call him communist, but I'm going to stick to my guns. He's the commie mayor in New York. And what else did we discuss yesterday, Nate? It's been a long time.
It was that in Prince Andrew.
Oh, that's right. The Prince Andrew story broke.
But you said somebody else got arrested, right? Another
the crown princess's son, I think in Norway, just got arrested, including charges, I guess, for 4 grapes.
Ooh.
So, and I believe it was Norway. But
it sounds like Europe, everybody's going down, but in the United States, we still hiding the, Well,
if you look at the guy's picture, any Game of Thrones fans, if you look at the picture of the Norway, I don't know what he is because he's the crown princess's son. So I don't know if he's a prince or what he is. I don't know if he is, but he does resemble Joffrey for all the Game of Thrones fans. Same energy.
It's weird how across the border, you got crown princes going to jail, but over here, there's nothing to see here. There's obviously, I think, something to see here, but we'll figure it out because Pam Bondi and them aren't going to be in there forever. But I have an open bet with someone about $100 that even if the Democrats if we don't hear anything from the Epstein files while Trump is in office and he leaves office, I don't think if a Democrat gets in there, they're going to be releasing the Epstein files either. I think it's going to be the same.
Oh, of course they're not. And if, the way I always look at it, like, oh, well, they couldn't because they were court bull crap. They could have done whatever they wanted to do. Let's not act like they wouldn't. If there was anything good, they wouldn't have let him become president. I mean, they leaked his tax return, so yeah.
Well, I don't know if I even follow that logic because there's a lot of bad stuff in there. What we've seen if that came out. But I think it's more mutually assured destruction. I think.
Oh, I agree with that. I agree. Like
they're just as implicated as the Trump side. Mm-hmm. So it's like putting it out doesn't help either side. It destroys them both.
Well, no, that's more of what I'm getting at. Like they all know there's nothing they can gain here. But that's
Well, yeah. Did you expect this to set England on fire though? Because that was not necessarily anticipated. I mean, everybody knew about Prince Andrew. That's like the longest running Epstein story, I believe, out there is Prince Andrew. And of course, Bill Clinton knew the guy and Trump knew the guy. Those are with a big 3. But did you realize that, that Keir Starmer, they're talking about how his entire government is completely under threat. I would make the argument that Prince Andrew being arrested helps Keir Starmer delay potential problems because everybody's focused on that versus his diplomatic friends who are caught up in the Epstein files, or specifically one friend who I think was an ambassador. So there's a huge ripple effect. And then now you've got the Norway thing. I did not anticipate the England European angle. What about you guys?
I mean, nothing usually ever happens. So, yeah, I didn't expect anything to happen to Prince Andrew. I'm pleasantly surprised, but I just didn't expect anything to happen. And even what's happening to Prince Andrew isn't about him, doing anything atrocious. It's about him leaking financial information to Jeffrey Epstein about the goings on of world business. It's not, which yeah, he could face up to life in prison for all that, but it's like nothing's really going to happen to him, and he's already on his way out with the royal family, and like it's not going to change that much. So no, I'm not surprised, but I was also kind of like, nothing's going to change.
I agree with Sean in terms of there's nothing to do with the actual Epstein nonsense. This is all about giving away state secrets, right? He's giving away state secrets and insider trading, essentially. But
that's something that a lot of people have overlooked with Epstein. Everybody is focused completely on the females involved with Epstein. I'm just going to say that for the whole scope of girls and women, but there's a lot more to Epstein. I mean, the guy is tied in with running arms in the 80s of the CIA. This is potentially like insider trading and financial crimes that Andrew is getting caught up with, which is, possible state secrets. Well, why was he giving away state secrets? Was that because there was something on him by Epstein? I don't know. It shows that the scope is a little bit wider than what everybody is talking about, in my opinion.
Because I think whenever you're talking about criminal law, you kind of got to be led by the facts. And I think he wouldn't face these charges unless they saw those emails where he's directly, saying, "Hey, you should do this. You should do this. I'm going here. Here are these state secrets." So I think that type of evidence you can't overlook, right? It's just blatantly there. So it's kind of, but I think when it turns into the other stuff, those things are usually done in private. If there's video stuff of that, then I think Andrew would have an issue. But right now you just don't. At his position, being a member of the royal family and being eighth in line to the British throne, I still think you just need more. And I think right now, unfortunately, they have him at least dead to rights on the state secrets. I think they just got him dead to rights. They have the emails. It's like, what more do you need?
Yes.
Oh yeah. I mean, and that's brutal. And for those who are talking about a potential life sentence, as I was saying yesterday in our show, Andrew is 66 years old. Even, 5-10 years could be considered a life sentence for the guy.
I don't even think that's going to happen to him, though, honestly.
Well, my theory is he'll wind up being kind of exiled somewhere similar to his great uncle. But I don't know for sure, what'll happen. And it's still interesting.
Oh, it's very much interesting.
Yeah.
And if chat doesn't know what you meant by his great uncle, what
George
became
the First?
Well, it was Edward.
Edward, his brother. Yeah.
George. Yeah. So there were two kings in the 1930s. There was King Edward, and he wanted to marry an American woman. Kind of like Prince Harry vibes there. And she was divorced, and they wouldn't let her do it. Yeah, they wouldn't let him do it, so he abdicated the throne to King George. And he lived as a pariah, and it turned out he was, big friends with the Nazis.
Yeah, he's a collaborator potentially.
Yeah. Oh, well, and there were apparently claims that he was going to help the Nazis destabilize the English monarchy, and then they would let him come back in and run the show after they won the war. So, yeah, he. If you guys have ever watched The Crown,
I think is
Wallace, yes.
And by the way, going further on the Nazis, not only was there an odd relationship? I'll just say that odd relationship. Is that fair? There were questions whether he was being cuckolded by senior Nazi officials.
Well, yes. Apparently, Wallace may have been getting doinked by von Ribbentrop when he was the ambassador to Britain.
Oh wow!
Yes.
There's a lot going on here. Yeah.
Oh yeah.
Yeah. So you can see where Charles. By the way, as I pointed out yesterday, there was another Charles. His name was King Charles. 400 years ago, he was the last guy arrested, or last royal arrested, and things didn't work out so well with him. His head was separated from his body ultimately.
Yes. He did quite a few questionable things though back then.
Yeah, but his thing was about raising taxes, right? Because that's when they passed that law that.
Well, no, he was conspiring with the French and Scottish governments to wage war against the British people, and he had stormed Parliament with the army. He did a lot of things.
Yeah, he was. And what is it, Lord Protector? Right, that's where the term Lord Protector.
Well, that's where Oliver Cromwell, yes, because he
Cromwell,
took over.
And then all of a sudden, his son became hereditary. He's now the Lord Protector, so it became really
well. They tried to do that, but then it only lasted for a little while, and then they came back. The Stuarts came back, and Charles II took back over. Only like 12 years of no king.
But significant for the people at the time. I mean, it had to be interesting. Situation.
Popular sovereignty definitely became a thing.
So do we transition over to now what the people have come to see?
Yes, we have 307 people here now. I don't know where everybody is. So 314. And by the way, have you guys considered hitting the like button? Because it really kind of would help out a ton. Yesterday's video, I hope you check out too, was demonetized. Thank you very much, YouTube. So any help, getting the word out, etc., because that tends to suppress its reach. So you're liking this, you're sharing with people. It all really does help a ton. It really, really, really does. But yeah, today we have a little bit of a, small decision from the Supreme Court sort of happened not long before showtime. We've been waiting for a while for this to occur, and it may turn a lot of the world upside down. So I'll let Nate discuss the tariff decision because I think he wants to start dancing around the room and saying something.
Oh yeah. That I was absolutely right, and it was an easy case. But let's just go back to what actually happened. SCOTUS strikes down IEEPA. So for those of you who don't know, this was the Learning Resources Incorporated versus Trump, and the issue was
it's not leering for the Minnesota folks. It's learning.
Learning, yeah, the Learning Center, the Learning Resource Incorporated. Now, this is essentially a group of importers and exporters who were saying that the president, Trump, didn't have authority to issue the tariffs in the way he was issuing tariffs. He could issue them in an emergency. There was like an emergency provision called the IEEPA, the International Emergency Economic Powers Act of 1977, which Congress delegated some authority to tariff in certain situations. Like, for instance, if you want to protect a particular market, like we have some of those emergency tariffs going on now with electric cars. For China has a whole bunch of cheap electric cars, but they have a 100% tariff on those particular cars because if they bring them to the U.S. market, they would destabilize it. Essentially, everybody would buy those cheap electric cars from China instead of buying the Teslas and stuff. It would destroy the U.S. market. A lot too. Yeah. So that's one. So the way the law worked was that the president had to declare a national emergency. And if he had a national emergency, then he was able to issue these tariffs to quell that national emergency. That's what the International Emergency Powers Act for. So the statutory language says the president may regulate importations and exportations. But interestingly enough, the IEEPA does not mention tariffs or duties. It just says importation and exportation. So this was a 6-3 Supreme Court decision. The justices in the majority were Chief Justice Roberts, Sonia Sotomayor, Kagan, Gorsuch, Barrett, and Jackson. They were the majority. And the 3 dissenting judges were Thomas, Kavanaugh, and Alito. And there was this, when you guys listen to the news today, you're going to hear a lot of people saying it was a convoluted opinion, but it's like 120 pages. But there's like 2 opinions. So there's multiple opinions, but there's one opinion in which all 6 justices said, yes, we agree with this. This was based on the statutory interpretation. So that's the part that goes into precedent, right? Based on their interpretation of the statute, the president doesn't have this power. But there's a second kind of minor holding in here where 3 justices relied on the major questions doctrine. And that's Roberts, Gorsuch, and Barrett said that because this is taxing is a major question, then the president can't then use the power of the legislature to impose taxes. So, but that wasn't the majority opinion. That was a minor opinion. And then the 3 dissenting justices said he could use it. So the issue was, does the International Economic Powers Act authorize the president to impose tariffs under the power to regulate. And this is where we get the back and forth and why this happened. So is everybody with me, or any questions or any injections right at this point?
No, I'm with you there so far.
All right. Matter of fact, I'll put these show notes on the screen. Why am I hiding the show notes? I'm sitting here reading them so we can all see them together. Sorry.
Right now, you're just talking about the background and what was being discussed.
Yeah.
There's not much to really
so far, I
debate.
agree.
That's just
and chat. This opinion's 170 pages.
Yeah, I'm
massive.
And so just so everybody else understands too, we send the show notes to all the attorneys before so they can look at it and see. So everybody already has this, and people who are going to probably come in later.
Dude, you're making us not sound as smart. Like, don't ruin the allure.
No, they do it for me. They do it for me. You're okay. It's for me.
What about the fact that we would just so we can be prepared? But anyway, so first, the constitutional baseline. Obviously, Article 1, Section 8 says Congress has the power to lay and collect taxes, duties, imposts, and exercises. So the Supreme Court affirmed that tariffs are a branch of the taxing power, and they cited these cases, Gibbs v. Ogden, Nicole v. Amos, to say that the power to tax and lay tariffs are under the purview of the legislature. The government conceded at this point the president has no inherent peacetime tariff authority, so they can't tariff. Congress has that power. Then the court then goes into the major questions doctrine. And the major questions doctrine is essentially if Congress if a branch of government wants to do something, like if the president says, hey, I want to lay a tax out for everybody, and it's delegated in a way from the legislature to Congress, the president can raise these taxes. The major questions doctrine says, no, you can't do that. This is just such an important power that the legislature or the court or the executive has to speak for themselves. So that's what that major questions doctrine comes from. And the Supreme Court cited these cases, West Virginia versus the EPA. And if you're in law school, you know this case because this is a case that most law schoolers know, where agencies need clear congressional authority to exercise powers. You have Biden v. Nebraska, that was pretty recent. And that's the student loan cancellation, where, again, you need Congress to do that. And they get NIMBY versus OSHA. Again, these are all for those things. So, but remember, only 3 justices said this was under the major questions doctrine. So this isn't the law. This is the law. We talk about statutory interpretation. So all 6 justices said this failed under the statutory interpretation of the IEEPA. Are people following me? I hope I'm not boring the chat to death.
No, hey, Runkle, this is going to potentially affect your country too.
So, statutory interpretation. Congress repeatedly. Now, what this means is that did Congress allow the president to impose these taxes under it? Right. The statute says Congress says duty, caps rates, impose limits, requires procedural findings. The IPPA does none of this. Right. It doesn't. They say it doesn't allow the government. The Supreme Court says it doesn't allow the government to impose these types of taxes. So what I did was ask let's go with the government's argument versus what the court said about the government's argument. So here's the Trump administration's argument and how the court addressed each argument. So first, remember, we were all arguing, myself, Joe, and we were all arguing about whether this was a regulatory tax. The Trump administration said these tariffs under this law was to regulate commerce. If you prohibit imports, you can impar or lessen the burden. And obviously, the government cited a couple of cases like back when the oil embargo of the 70s and things of that nature, that we can stop tariffs if it's an emergency. The court's response is,
I think some of the tariffs Trump was doing, I think everybody agreed, kind of felt like the fentanyl tariffs, because there was a very specific point about fentanyl coming in or whatever to stop that particular thing. I think those might have cleared. I haven't read the whole opinion, but that would be an example, right, of the emergency.
A couple of these have survived.
Problem,
yes,
etc.
Yes. So specific tariffs like the one against the electric cars, the one against fentanyl, the piece of fentanyl, those survive. But the broad tariffs, like 15% based on, because essentially what they were attacking was the rationale that you can just tariff because of some trade imbalance. And that's junk. But again, the court's response to this regulate tariffs was that the regulation and taxation are distinct constitutional powers. And they cited these cases, and they said the key distinction is taxation is different than regulation. What Trump did was by the 15% across the board, that's taxation. That's not regulation. The government then made the historical argument that, hey, the court at one point upheld a temporary 10% surcharge on trading with the Enemies Act. The court response was that this was a single intermediate appellate decision, limited narrow focus, and did not establish a well-settling meaning. So, and they cited this Kemp v. United States. Congress incorporates judicial definitions only when the meaning is well settled. And they said, so that wasn't well settled when it comes to their historical argument. And then they make one last argument that says Section 230 of IEPA allowed licensing. So in other words, they're saying, hey, we should treat this more like a licensing fee, not a tariff. But the court said Section 232 expressly references duties. IEEPA does not. IEPA doesn't represent duty, so it doesn't apply. Again,
our friend Aviva Fry is not here, but every time you're saying duty, I can't help but think of him playing the Simpsons clip about
duties. But again, this is the court going through each one of these arguments saying, well, none of this is convincing us. Then we have the emergencies argument, right? That Trump is saying, hey, this is an emergency, right? IEP is an emergency statute, board of meeting. The court said Youngstown sheet so everyone who went to law school in the United States knows Youngstown is a seminal case. Yes. The president cannot seize steel mills absent congressional approval. And essentially, the emergency powers tend to expand executive authority. But essentially, in this case, the government's argument, the government is saying was saying that this isn't like Youngstown, but the Supreme Court says this is like Youngstown. And if you're going to use explicit authority from the legislature, they have to explicitly say that you can use it in this way. And in Youngstown.
Oh no, Nate.
No, it was him. I thought that might have been me. Go ahead again, Nate. Repeat that.
Oh, sorry. I'm cutting off. Sorry.
Yeah.
Well, so essentially the president couldn't seize steel mills in Youngstown without congressional authority. He can't impose tariffs without congressional authority. That's essentially what they're saying here. Then they had a foreign affairs argument. Trade impacts foreign affairs, and that the president is the person who deals with foreign affairs. But the court's response is that the Constitution explicitly gives tariff power to Congress, even though tariffs affect foreign affairs. So, yes, the president is the chief negotiator, diplomat, foreign affairs, but the Constitution specifically says tariffs, so for Congress. So even if it affects that, it doesn't matter. So the key structural points: no president in 50 years used IEEPA to impose tariffs. Congress knows how to delegate tariff power explicitly if they wanted to, and the IEEPA excludes export regulations, but export taxes are unconstitutional. Includes export regulations, but export tariffs are unconstitutional. Reading regulate to mean tax would create constitutional problems. So in conclusion, they say the president was not authorized to use. So any tariff that he implemented under IEEPA, under these theories, he was not authorized to use. The federal circuit was affirmed. The DC circuit was dismissed for lack of jurisdiction, but the Court of International Trade, which also made this ruling, has exclusive jurisdiction over tariff cases, and so their ruling was upheld because they ruled that this was also unconstitutional. So that's where we're at. So right now, there also may be a repayment mechanism, because generally in administrative law, if the president makes a fee or a tax or something that the court finds to be unconstitutional or unlawful, as it has done here, then generally it's unlawful from the beginning. So now there's going to be an issue whether the government has to pay back all those tariffs to those companies with interest. So that's going to be the next fight. And now
I have a question on that, Nate.
Back for that.
And I wanted to ask this question because technically, if the tariffs are considered a tax of sorts, the ultimate person paying is the consumer. Even if it's going to businesses, the consumers are paying it through raised prices or whatever. Trump was proposing a quote-unquote tariff rebate. I don't know if you remember that. It was a couple months ago. And that would technically go back to the American taxpayers. If he was to put that in effect, would that serve the quote reimbursement requirement? Now, I'm asking both you and everybody in the panel. I know it's a different question.
Well, I don't know. Go ahead. I'm not sure, to be honest with you.
Well, I mean, can you re-ask that, Eric? I'm kind of
because it's kind of confusing.
All right, Trump is proposing a tariff rebate. Like, hey, we've earned X amount of money on the tariffs. I want to give everybody in America X $2,000. I'm just throwing a number out there.
Okay.
Yes.
Since the American people are the ones who ultimately were paying the jacked up rate or the cost of the tariffs, under the tariff is a tax question, and the consumers pay the prices, would that be considered reimbursement? Is all I'm asking.
I think you're going to get an argument saying these aren't the people who ultimately paid the tax. The tariff.
Yeah.
I'm the importer. I paid the tariff. Here's my receipt on the tariff.
Yes.
Why are you giving it to Joe on the street?
Did you raise your prices?
Me?
So what?
Probably, but
I'm still the one who paid.
And
that's more of a traditional thing. Is like if I end up incurring the cost, and then I had to pass it on down the road to other people, I'm still the one who sees the reimbursement as a legal remedy.
Which is ironic. So then the people who truly suffered are the Americans, and the business owner has got to be thrilled. Oh, look at this. I get the money back, and I already passed on the costs. Hey, yay me. My profit just went up.
They're probably not going to see any. They're not going to see any reason to put the prices back down again afterwards.
Why?
That's kind of the ratchet effect.
Yeah.
Once you push prices up because of a tariff, they don't come back down.
And
they
you have
just,
And you have to, because the shrinkflation is all this other stuff. And you also have to blame the person who illegally did, because we were all, some of us were always saying, this makes no sense. The reasoning for the tariffs makes no sense. The formula makes no sense. This is not going to survive any type of scrutiny. And now it hasn't. So the person who came up with this whole nonsense is the person responsible, because now the businesses, I think, have a legit argument that, hey, we should get paid that tax back. And unfortunately, the people who actually it was passed on to, they're going to have to eat it. The people who are screwed in this whole ruling are the American people, for sure. They're going to be stuck with higher prices. And I just don't see how you get around it.
Well, first off, that was Nate. You said this nonsense. I just want to make sure everybody agrees that it was nonsense.
Like doing this, or the way he did it.
The whole program, using the tariffs, all of that. I'm just curious.
As a Canadian, I will agree it's nonsense.
I mean, he's the right to try to do it. I mean, I will point out that Kavanaugh's dissent just points out, like, there are literally a million different ways. He could say, fine, no tariffs. I'm just embargoing all imports from that country. So it's like, apparently he can go completely insane. Like, because that's the IEEPA is used. That's why, like, if you try to go do things with Russia, it's sanction violations, because those are, executive branch sanctions. So he could say, fine, nothing coming in from China at all. Is that really the step we want to say? Like, oh no, you can't charge any money, but you could just completely nuke trade. Kavanaugh points out, like, I don't know if that makes any sense. And then there's also, just as Kavanaugh points out, and he kind of basically says, as we heard during the oral arguments, there's a million different other ways that this could be done, which is what they're, was kind of telegraphed. It's like, all right, so he'll just do it a different way. It's not that he can't do it at all. It's just this way is not acceptable.
Well, that's kind of a poor argument, isn't it? Because then it's saying, well, then why didn't he do that to begin with? If there's a million other ways to do it,
well,
why didn't he choose one of the million other options that are potentially legal or proper?
Yeah, but those other ways take time.
Yeah, and that's I think there are two things. We can't argue what would have worked or what we think would have worked. We got to argue what they did, what they argued. And their argument was the emergency was the trade imbalance between the United States and various countries. And they raised tariffs on everybody. They even raised tariffs on countries that didn't have trade imbalances, right? They raised, we had trade surpluses on. So this was across the board tariff raise. And that logic was just blown up by the Supreme Court. That doesn't make any sense. That seemed to be nonsense in that particular way. Now, the Supreme Court did lay out, you could have done it all these other different ways, but that in no way doesn't mean the way that they did employ it was nonsense. And they literally broke it down and said, this was bad, this was bad, this was bad, this was bad. And now, if you want to do it, you just have to do it the right way. and I think Sean is right. They did it this way because they tried to save time. They wanted, what was the quickest way to do it is say, there's an emergency, and that's the way we can do it, instead of just going through the proper procedures.
Right. And I will say that one person who has been saying that for a while is Sean Spicer, who was a former press secretary under Trump in the first administration. I guess his other job was working on the international trade commissions or one of those. And he stated that he always had problems with the emergency authorization angle. He said he was commenting that they can go in and then go into the full-blown negotiations, like the panel or whatever, and then reset the tariffs after voting or what have you. So I agree that there's some degree of precedent with that.
Yeah, but this is I think essentially at the end of the day, what this comes down to is it's going to be great for the U.S. economy because all those businesses are going to get those billions of dollars back, and Wall Street's going to be going off the chains right now because now how much have they collected in tariffs? So you're getting not only the tariffs back, but you're getting the interest rate back, and then the people who've already paid the extra higher prices. If prices go down, it'll be great. But I would hope prices would go down because now you don't have to pay the extra 15%. But we'll see. Because
I am a little more cynical, like Sean, on that one. That's when you said hope, it's like hope in one hand and poop in the other, and see which one fills up first.
Yeah, but would you, if you're a company and everybody's now used to paying 15% more? Would you lower your prices 15%?
Well, that's the point.
No, they don't.
Yeah, exactly. Thank you for expressing his exact point.
I'm not.
You just said that.
Yes. Yeah, that's what I'm saying. I'm not. What I'm saying, that's just good business, right? If people are used to paying extra 15%, sure. That's why I said the only people screwed in this is the American people.
Yes. Always.
Yeah, that's true.
And there is unfortunately it is hard because a major tool was taken out of his toolbox, but we'll see. Supposedly, and I don't know for sure, he was expecting this decision for a while, and I think behind closed doors maybe they've been working different angles or whatever else. So I'm not sure how it's going to shake out.
Yeah, but I think people really need to understand how big a transfer of wealth this was from direct consumers to companies to the government. And now the government has to pay back that money to the companies plus interest. So, like, again, that transfer of wealth was huge. Now, I don't know how it's going to affect the overall economy, but that's that money's not coming back to the everyday people, which is
of course it's not
crazy.
It never is, Nate. It never is. It's always a big transfer of wealth, in my opinion. If you break it down, it's like too big to fail. Who benefits from too big to fail? The consumer? No,
the bank that's too big to fail. Here, Wolfpack,
the business. GM wasn't a bank. General Motors.
Oh yeah,
wasn't
GM
a bank.
too. But the bank was one example. But yeah, GM too.
Yeah.
Or how was UK Gov is deleting the G gang's paperwork? I'm not sure.
We'll just say grooming groups of people is what he said.
Yeah.
Go ahead.
And yeah.
One, I think companies will demand tariff refunds, of course, right? Of course, and may come via the tax code. Yeah, they're probably going to. Yes, companies won't lower prices. They'll enjoy these new margins. Of course, of course. Yeah. We definitely agree. Nate, stop being idealistic. We don't live in an idealistic world. I don't know how I'm being idealistic. I'm just kind of read the.
Well, when you said that you hope that it went back to the consumer.
Oh yeah. That is
a little idealistic.
Yeah, that is definitely idealistic. But it's just like, what can you do? What can you do? So, you know what? So should we go to so next we have the trans case where the judge ruled that.
I thought we were doing Colombia, but we can do trans.
Colombia. I was in Colombia.
Didn't know if Joe was going to show up. So
yeah. So let's do. We'll do Colombia next. All right. So.
Runkle, I want to hear from Runkle because I want the Canadian voice and all of this because he's sitting there like, I don't know. I'm glad I'm here.
Well, now for Runkle, you guys don't have any more tariffs. He can't threaten to tariff you anymore in Canada. There's got to be a good day for you guys up there.
I mean, he still keeps threatening annexation and various other things. So, I mean, we're just kind of waiting this one out for a bit.
Well, at least now you get all your money back too, because you got to pay all those companies their money back.
Well, except those are all U.S. companies, and they'll be being paid out of, because the tariffs are paid by the companies who are importing it on arrival. So it's all U.S. companies who are paying the U.S. tariffs and then passing it on to U.S. taxpayers. So, I mean, none of that is going to a Canadian company because we didn't pay the tariffs in the first place.
But it will help your exports potentially.
It likely will. I mean, especially if the margins, if they don't drop prices and suddenly all of these tariff products now are products that have an extra margin.
Yeah, like 50%.
I mean, at that point, it's basically a gift to Canada. So, I mean, I'm guessing there's some 5D chess or whatever the line is that people are use to always justify political decisions. It's yeah, I sort of shake my head at the whole thing.
And in fairness, with the annexation talks or whatever, there's a couple provinces, I think Alberta, that threatens to come over willingly.
It's at about 20%. Now, to keep in mind when you're looking at that, if you do a poll as to whether the moon exists, like not was the moon landing fake, but like is the moon a thing, you'll get about 20% of people saying no, because that's about the range of like any question. You'll get a certain margin of.
You're saying it's possible.
I'm saying I wouldn't count on it. The thing that's most likely to happen is they'll have a referendum and it'll fail. And if, I mean, I suppose you could see people going, this is a fake referendum. So,
it's never stopped Quebec from trying for referendums.
Wow.
Yeah. The thing is Quebec can keep pushing it for forever and a day, but Quebec also has, because of the way sort of Canadian politics works, Quebec has this outsized level of power. Mm-hmm. It'd be like if California has, if like it was impossible to win the presidency without California, like just impossible. Not
so it's like the ultimate swing state. Is that what you're saying?
Pretty much.
They have
every politician has to appeal to Quebec.
Yes,
or else there's no hope. That's about it.
Yeah, and they have their own political party, Bloc Québécois, and it's very interesting. And
so they have should encourage them being separated.
They would go their own way before they would go to the United States.
No, Quebec. No, I'm not saying that Quebec would. No. Quebec is, I think, their own animal, and they prove to be violent about it. I feel the parallels there are a little closer to Ireland than the trash talking from Trump in Alberta.
Yeah, the Alberta stuff right now is it's kind of a fringe discussion, and I don't expect it to go anywhere. The other thing is that most of the people who are either in favor or opposed to this have no idea of what the courts and the government and so forth has said the process for separation is, because in Canada, with Quebec saying, hey, we want to go, and actually coming pretty close on a vote, we had to actually figure out like what would separation look like, what would be required, and it's such a nightmare of
I didn't know that they actually had to sit down and think about it. I thought they just said, lol, no, you're not leaving. And
no, I think
really?
They have
Supreme
that right.
Court. They sent a reference case to the Supreme Court, basically asking, can a province, leave? And the Supreme Court is like, yes, but here are some requirements. And they actually have sort of tried. There's a Clarity Act, which is sort of attempting to regulate how that would look. But apparently this is like the leading case on breakaway countries, because when I did a semester in Norway in law school, and one of the classes I took was international law, and they're like, so here's the case, and it's out of Canada. And it's like,
hey, hi.
Okay.
You're just like, oh my God, why do we have to do this?
Exactly. It's like, okay, Canada gets a mention and it's for this. Okay, wonderful.
Oh, since
Joe is here, I wanted that. I was assuming, Joe would have a definitive opinion about the Trump tariff decision?
Yeah, we just went over it. So
I think that I'm still digesting the decision. Like I was literally doing this as we're looking at it. I think the major questions doctrine is kind of ridiculous. My take on the whole tariff thing was I don't think he has the authority to do it if Congress stands in his way. I feel like because I think the Emergency Powers Act does empower him. That was my read of the statute. But before the Supreme Court weighed in, to me, the natural reading is that he does have that power. If Congress stands in his way and says it doesn't apply here, that would sort of serve as a revocation. That I wouldn't think you would need to have an entire statute passed, because obviously he would have to sign off on that. But that if Congress would stand up against it, that could serve as a revocation in this particular application of the Emergency Powers Act. I think that's a logical way to understand the statute. And I do think that standing on his face, under Article 1, Section 8, that duties are reserved for Congress. So I think that looking at this as a constitutionalist, I think they did cede that power with the Emergency Powers Act. I think that if you could have gotten the majority of Congress, and I mean both houses of Congress, without his signature to basically resolve that this is an overstep, in that case, that would be a retraction of it. And I felt pretty confident that the Supreme Court was going to take it away. That being said, I think that I had a whole debate yesterday with a libertarian who's very against taxes and basically was saying that tariffs are always terrible. And I think that when the Constitution gave the power of tariff exclusively to Congress for them to wield as they want, or in theory to cede over as they did with the Emergency Powers Act, that they were looking at tariffs as a way of raising revenue, and that's why it's all incorporated under part of taxes. And at that time, the United States was obviously in its infancy, and they probably couldn't conceive of a time and place where the United States would be the predominant world power. We were relatively small compared to most, established nations. So they were looking at us as a relatively small power and didn't recognize the financial influence that we could wield, or the power that this could serve to be in the hands of an effective president who wants to use tariffs for the purposes of trying to influence our relationship on the international stage, which is his exclusive domain. And when you consider tariffs from that perspective, I think that should be a power which is actually uniquely for the president, not for Congress. Tariffs has that duality. It could be tax raising, which is congressional, or it can be a way to, influence our negotiations and our leverage with the rest of the country. But that leverage was not a possibility in 1789 when the Constitution was drafted. So I don't think they conceived of that, and they looked at it exclusively as a congressional taxing type of power. But given how Trump has been using it, and effectively using it, to negotiate and strengthen our position on the world stage, I think that even if you want to say that as an originalist or as a historical perspective of the Constitution, that this is not something Trump should have been doing, I think it's embarrassing that Congress is not supporting Trump, because the America First position is he is using it to put America first over other nations. That is what the America First position is. America First says, hey, look, maybe he shouldn't have been doing it. Maybe we had to give him this authorization. But seeing as how the objective is what the objective is, and the success he's having with that objective, we should be supporting him in this context, because he's clearly using it not as a revenue raising thing, even though he's going to proffer that to promote it, but he's using it to help our American industries compete on the international stage, to lower tariffs across the world, to have healthier negotiations with the rest of the world. And seeing as how he's using it in order to help enable him to be a better president, a better person, a more powerful president in how he's handling his negotiations across the international platform. I think that it's embarrassing for Congress that they have not supported him, and that's the real shame of this whole thing.
Is that a Machiavellian justification, Joe? Ends justifying the means?
No, because what I was saying, I'll tell you, it's not ends justifying the means, because ends justifying the means would be for me to say he should tell the Supreme Court, go to hell. We do have a process, and the process is very important. What I'm saying is Congress should be intelligent enough, even though it sounds silly to pray for Congress to ever act with intelligence, but Congress should be intelligent enough to recognize the distinction between him using it as a revenue raising power or as a power designed to help us on the international stage and to put America interests first.
But that's a very interesting framing, because you can, I think the court even points to Trump saying we want to raise so much money, we get billions. Yeah. He's the one that put and his arguments from his team said literally, this is not a tax, it's just regulate, but it's going to make off all this money. And the court then cited a case from 1953, United States v. Koger, which says taxes do not cease being taxes because it regulates. It's still a tax. So
right.
It's
with Trump.
I think they're strong here on this law.
No, like I said, I don't think I'm not questioning the decision. I think the decision is probably correct given the set of circumstances. I said if I was in the Supreme Court, given how everything is written here and how things have played out, I probably would rule against him, even though I want him to have this tariff power. So I'm not slamming this decision as being inappropriate, because I think that as an attorney, I have to say that this is a fair read of how the law is written. I'm simply saying how the facts have played out. Congress should have ceded this power to him, because that is, and I know he's going to give messaging saying this is going to raise us money. Of course he's going to give that messaging, because he's not supposed to be caring about the economy. The president, that's not his job, but the president's always going to promote the economy. What he's going to say, his messaging to the people is not reflective of, it's not necessarily something that was supposed to say that this is what's actually happening here. You look at his actions and how he's dealing with things, and that's how you interpret his actions. I put much less stock in the words that he says or the promotional elements that he throws into it than looking at his actions and seeing the ramifications of his actions.
What about the political fallout of the fact that they were saying tariffs were not a tax, but the Supreme Court has definitively said in this ruling, I know a couple of people have read it, that this is a tax. Tariffs are taxes, definitively. So does that change because I know we all agree, but does that change the calculation on now are tariffs taxes? Because that was their argument for all this time, that these are not taxes, but the Supreme Court has definitively said they are.
Yeah, I don't really agree with that. If they were taxes, in that case, you wouldn't have to separate duties out from other taxes, right? So I think I think that's kind of a silly. I haven't looked at that part. Like I said, I haven't read through the decision yet. I really just looking through some notes on it. But yeah,
I mean, it is an import tax. That's how they work, right?
Yeah, it's operating as an import tax, but I think I was just laying out for you how, unlike your typical, the taxes inherently, first and foremost, taxes inherently are raising the price on the American. And this is not something that is inherently raising it. It can serve to do that, but there's a lot of ways that this can serve to not end up affecting the American consumer. If anything, could end up benefiting each of our bottom line dollars. A tariff could ultimately end up benefiting us. I was trying to explain this to the libertarian that I was debating with last night, which is, the tariffs can and often are picked up by a third party. So what ends up happening is you end up having a growth of the American industry, because in this particular context and the way Trump was using it, he was basically saying, hey, look, in Europe, we can't sell a single freaking American car. They haven't sold an American car there in decades, because the tariffs they put on our cars make it impossible for our manufacturers to compete. So if he ends up helping our car manufacturing industry, that ends up spreading out and affecting and benefiting the economy of America as a whole, which means that you are individually, ultimately, you're not going to see the dollar. You're not going to see an extra $5 in your bank account because of it. It's noticeable to you, but your overall wealth ends up growing as a result of American industry growing. So when he's doing that in this market, that market, look at what he did with India. Look at how he negotiated such an amazing deal when he's negotiating tariffs with India, which they were tariffing the hell out of us.
Well, all those are gone now, though.
They're gone now, but they might bring it back.
No.
Once they know we don't have the power, he doesn't have the power of tariff, they might bring it back.
Yeah,
I think
the Congress has to do it. Yeah.
Okay, one question on that though, Joe. Let's say everything you're saying is 100% accurate and true.
Okay.
And everybody probably can agree with that in a lot of ways. Isn't the problem though that he was using the wrong means, that he was using the emergency authorization and it wasn't specifically an emergency? Like not being able to buy a car from Europe isn't really an emergency right now.
I agree with you. I agree with you.
The deals and run it through properly.
I definitely. So that's why you're saying it's Machiavellian, because you're saying it's like the ends justifying the means. So like that's what you meant by Machiavellian, and I think that's a fair criticism. I do think that it was a pretextual type of way for him to get what he wanted. If that's what you meant by Machiavellian, I thought you were looking at Machiavellian as far as negotiating and trying to get Congress to do what they want. If you're telling me that he was trying to work within the framework, but what he was basically trying to do is he was trying to use the framework as existing and trying to make America better. And see, when I look at Machiavellian as more of like self-interest, that he's looking out for himself, and if you want to look at Machiavellian as far as how a politician can help further his agenda to help America, I don't look at that in the negative negative connotation.
Yeah, when I say Machiavellian, it's like, because in the case of Machiavellian, which is the prince, the prince is the state in a sense. Any royalty, the prince is the state. So if it's helping the prince, it's helping the state, potentially. So I don't necessarily mean it as a pure just manipulation.
But I don't even look at it as benefiting the government. I look at it as really ultimately benefiting Americans, because that's ultimately what's coming out of it. It's not even that it's less about the enriching of our IRS dollars, our treasury dollars, than it is of the betterment of how this helps the American consumer, the American producer, American manufacturer.
But even if you say that, based on this ruling, the people who have been hurt the most is the American consumer, because now these tariffs are going to have to be paid back because they were unlawful from ab initio, and based on case law that they're going to be paid back with interest. And these companies now have raised prices 15%. Unless they lower prices back down because they don't have to pay the tariffs anymore, which is probably going to be unlikely to do. You have the Americans paying higher taxes. You have the companies now getting all of this tariff money back that they don't have to give back to anybody. Like Eric was saying, they should give it back, but they're not. So the people who have been essentially suckered in this whole thing is the American consumer, right?
Which, by the way,
who are out the money.
Here's
and they have to pay interest on it.
I pray your read on that is wrong, and that's down the road. I mean, that could happen as far as having to pay it back. Is that what they said? They said it's void ab initio, these tariffs?
It's unlawful, yeah. So generally the law is,
because if you think about how backward this is, assuming that's correct, assuming what you're saying is correct, Nate, think about how backward this is. So the major questions doctrine is the impact that this is having on on Americans.
Well,
so
I mean, wouldn't it always be like that? Like if the government illegally imposed like a good logic tax of 100% of your YouTube earnings, and then it was found that was unlawful because Trump decided that was what was best for the country and was like, all right, 100% of his earnings. You go to court and the court says, no, that was unlawful. You want your money back, right? All of these people who put the money in and they should be entitled to it if it was an unlawful action, right?
But here's the thing: it's not their money back, because that money ultimately much of it ends up getting picked up by third parties who are not even American. That's my point. That's why the whole major questions concept here is kind of absurd, because if Nate is correct in his assumption, if you're correct, Nate, that we have to pay back money, look at what the Supreme Court just engaged in doing, playing economist. Like trying to figure out what's going to happen. Go correct me. You sound like there's something bothering you.
No. It's just because you keep saying major questions, and the ruling is confusing. It is confusing because I thought major questions too, but specifically major questions is not the holding, because only 3 Supreme Court justices, Barrett, Gorsuch, and Roberts, said they agree major questions applied here. But that was only 3. The majority, the 6. Said that this was a statutory interpretation. So you're right. Major questions, those 3 said it, but this whole thing came down to the statutory interpretation of IEEPA.
And I genuinely appreciate you correcting me on that. But we all know, and we've seen this we've seen this going back probably like now near 10 years. Well, I'd say 5 years since Amy Coney Barrett has been in there. Those 3 decide every decision. Because you always have every single case. I mean, it's weird to see Gorsuch. You said Gorsuch, not Kavanaugh. I would have thought Kavanaugh would have been in.
Yeah. So here's the 3 judges who. Well, here's the majority were the 6 in the majority were Roberts, Sotomayor, Kagan, Gorsuch, Barrett, and Jackson.
That's interesting. Kavanaugh went to the dissent.
The 3 dissents are Thomas, Kavanaugh, and Alito, and but it's split. So when it comes to the major questions doctrine, Roberts, Gorsuch, and Barrett said that they would have knocked it out based on major questions doctrine. But all 6 justices, which were Roberts, Sotomayor, Kagan, Gorsuch, Barrett, and Jackson, they said that it's no good based on statutory interpretation. So that's the precedent statutory interpretation. But then the concurrence is, hey, we also think this is major questions doctrine, but we don't have enough votes to see that through.
Look, I'll be frank with you. I think that 5 of the justices are almost predetermined based on. I can recognize this that Alito and Thomas seem to invariably go along with whatever Trump has put forward, and Kagan, Jackson, and Sotomayor will invariably go against whatever he's.
Barrett and Roberts pretty much.
That's just reading. If you read a dozen Supreme Court decisions, it's very clear that the other 4 are the ones who are deciding every single case. So when you're telling me that the 3 who sided against, so I don't care for, whatever justifications they're going to end up giving, so they didn't end up going into the major questions doctrine. I think the major questions doctrine, I've got real problems with it. And those are the ones who are ultimately deciding the case. I understand you're calling them the plurality, but they're the key players, because they're the ones who are deciding the case, because the other 3 are always against them. You know what I'm saying?
Yeah.
The other 2 are always going to end up being on Trump's side. So
no, I definitely agree. I just think, and I think what you're saying makes more sense in terms of those are the people who are actually going to move the needle either way they vote. And if they're saying major questions, then that's where it really is. But to get the precedent, they needed the 3 liberal judges. So I'm thinking they said, we really think this is major questions, but we're going to go with statutory interpretation because we want to get this knocked down.
But the whole major questions is such an institutionalist type of argument. Like, it's
just like if it's like Congress can't start pardoning people, right? Because it would be it's a major question. It's just left to that political branch. But with that being said, let's move on to our next topic: the deportation cases against pro-Palestinian students. That case has been terminated. The Trump administration is on appeal. Here is that. We're going to put this up on the screen so we can see the hot news read.
An immigration judge terminated a year-long effort to deport Palestinian activist and Vermont resident Mohsen Madawi. Madawi is a non-citizen from the West Bank. He was a student at Columbia University where he led protests against Israel's war in Gaza. Last year, he was arrested by immigration agents during a citizenship interview in Colchester. The feds claimed Madawi was a threat to national security and should be deported. Last April, a Burlington judge ordered his release from custody. Today, an immigration judge terminated that effort to remove him from the country.
So there were 2 people who were actually in this particular case. I sent them to you guys in the show notes, so you guys can see them in the show notes. So the first question was did this case have anything to do with the First Amendment? It did not, right? So the court did address that non-citizens have First Amendment rights, but that has nothing to do with this case. So a lot of people are going to be out there saying, yeah, this is a win for the First Amendment. No, it's not. This win was about whether they had actually proven, that these people, through clear and convincing evidence, could be deported under this standard. So just so everybody understands, these people were in the country legally. And if you're in the country legally, you do have due process rights and things of that nature, but they're limited. They're not the same as citizens. Like, they can't vote like a citizen, but you have a limited set of rights. DHS wanted to deport these people, and they used Marco Rubio to say, okay, Marco Rubio signed this letter saying that these people were threats to national security, to their ongoing national talks or whatever overseas, and Congress is giving them the ability to deport people like that. But now there's a legal standard that they had to meet, which is called clear and convincing evidence. So they offered to remove these people based on that. So the government was unable to prove through documentation. So they put this document forward. Now, when you're in court, if you put a document forward, it has to be authenticated. We got to show, they have this person come testify. This is what I'm saying. This is what I'm saying. We all know the authentication rules. The government did not authenticate any of the documents that they put forward to remove these people. And since the government didn't put anything there to authenticate, they essentially didn't have any evidence to show through clear and convincing evidence that people should be removed. So the judge said, well, we've given you this time to authenticate these documents to show us why these people should be removed. They didn't, so they ordered them released. So that's what this case essentially is about. The Secretary of State's memo wasn't enough. He would have essentially had to come and testify, say, I wrote this memo and these are the reasons why. They didn't do that. So that's the reason why. So you're going to hear a lot of people talking about First Amendment with this case, but the First Amendment didn't come into play. This was strictly a procedural paperwork issue.
Question: when you say the Secretary of State would have to come and testify, would he personally, or could a representative from his office also serve the same function?
Well, I'm assuming. Go ahead.
That would depend, but I have the feeling the court would say,
Hi, Joe.
who wrote the doc, who signed it, I want that person here. And that would be the argument I would make if I was representing these people. I'd say, no, not somebody from the office. The guy who signed the document needs to come and tell us what he was thinking.
He was go ahead, sorry.
When they send like a representative, there's this trick that they use, and I know this because I've had it used against me, but they'll send a representative who only is briefed to be the witness, and so they're only briefed on like the official party line. And so all you can get is like, here is how this supports us. You cross-examine them and they're like, I don't know that. I don't know this. I don't know the other. So, I mean, if I was on the other side, I would definitely want the actual person so that they can't weasel with all of these. I don't know that. All I know is the part that helps our case. It's like, no, I need the guy who knows everything.
So the court says specifically that the Department of Homeland Security failed to authenticate the memo allegedly signed by Secretary of State Marco Rubio, the one saying that we need to deport them because they were hurting us. And without the authenticated evidence, the Department of Homeland Security has failed to meet the standard of clear and convincing evidence, meaning that this removal proceeding is terminated. Now, that doesn't mean they can't bring it back and they can't have Marco go up there to testify. Yeah, this is the reason why, but they didn't. So. And I think the lawyers here would know if you can't authenticate the evidence you're bringing in, then it's like it's worthless, right?
Is there a higher court? I mean, can go all the way to Supreme Court and flip again?
So this was in an immigration court, so they can go to the Board of Immigration Appeals, and that is just like these immigration judges, it's all within the DOJ, and they can appeal. And then from there, after you lose that appeal, you then next go on to whatever circuit court you're dealing with. So I think it's Vermont. They'd be like in the First Circuit. And then from there, they could go from the First Circuit up to SCOTUS.
So there's
I have the feeling SCOTUS will,
escalating.
I mean, even if they were to take this, they'll say, look, it's an evidentiary thing. Like, they're probably going to side with the judge on that one. Like, look, he's just asking for a specific standard. I don't think it would help the government to go that far. It's kind of like the thing with Kilmar Abrego Garcia. Like, just, they keep screwing around in the district court with his case. It's like, just do it the right way and be done with it. But doing it that way acknowledges you didn't do it the right way first.
I got to ask you guys, Pam Bondi, like, they are making some of the most trivial problems with these cases, like not being able to authenticate the memo. It's like you don't even have to have Marco sign the memo. You can have a subordinate do the memo, and then that person come testify. Like all these cases, these like
I thought that was Homeland Security and not DOJ.
Like, losing on authentication is kind of embarrassing.
Yeah, like so DHS. So the way the case goes, DHS is the removal, is the enforcement. But the reason why they're deporting them is because the Secretary of State is saying they are hurting my ability to negotiate with these countries overseas. Right. So that's the reasoning. So,
but that's not Pam Bondi, is all I'm saying, right?
Yeah, Pam Bondi is the one that's
DOJ.
prosecuting the case. Yeah, for the DOJ.
Oh, okay, I'm asking. I literally don't know.
Yeah, the DOJ handles. They're the prosecution wing, so they handle immigration. Like if you're being prosecuted in immigration court, they're the ones in charge of that. So the immigration judges are DOJ employees. They're not like federal judges in the sense of the Senate confirmed them. They're all DOJ employees. So the Board of Immigration Appeals, they're considered administrative law judges. They work for the DOJ. So
so this is Trump's own people that are spiking it down, in other words?
Yeah, this is Trump's own.
The immigration judge could have been, a lot of those are more career people, but but the DOJ itself, like the person who was prosecuting it, just didn't get it done.
Well, I don't care about career people. I meant in terms of a branch. It's administrative.
Oh, yeah.
It's all the administration.
It's within Article 2.
Yes, this is all Trump's people. The ruling, all that stuff is all Trump's people.
Mm-hmm.
So it could get moved to the judicial branch next.
Possibly,
they still have steps to go. But
don't forget though. This is not like an interpretation of the law. This
No.
is you presented evidence, authenticated, and they just like so. I don't even think this gets to an appeal. I don't think this gets anywhere. It's like because the appeal is like, what's the question of law? Unauthenticated
like
evidence.
I said, they're gonna say like just do the thing. Like even the Supreme Court, even Clarence Thomas is gonna be like, just authenticate it, and they're gonna be like, well, and he's
Runkle,
gonna he say this is a problem.
Runkle, do you think like
I
there's
can't
any appealable issue here?
I mean, it's just you are required to authenticate evidence. This is not like a new principle that the court invented. This is something that's been in place since the beginning of time. This isn't like go appeal it. It's just bring the case again, but bring the case with actual, with actual evidence. Like the court's like, but you have to. And they're like, yeah, but we don't want to. Okay, but
so in other
anyway.
words, it's similar to the Don Lemon case, right? Because from what I understand, the appeals court there said, you have other means. Did you go through the means? And then they went to the other means and they got it there. I mean, would that be a similar analogy?
Pretty much, yeah.
Yeah.
Just get it done. It's not like we're not getting involved.
It's like, well, why are we going to work so hard when this is something simple? Lawyers, like in the next case, the lawyer has of evidence he's got to authenticate. It's just literally, it's either putting Rubio on the stand saying, yes, I wrote this memo. Yes, this is the reason why, blah, blah, blah. And you're done. That's it. It's essentially, that's what they need. Or somebody else who's in that, like Runkle said earlier, but they didn't do it. So it seems like, let's take down some of these super chats before they get backed up on us. Roberts finds this effectively a tax, but not the ACA. Roberts did find the ACA to be a tax. That's why it survived. Yeah. Mm-hmm. So you're wrong on that.
Hypocrisy among the judiciary. I don't know.
No, he did find. He found the ACA.
Yeah, he found the ACA to be a tax. That's why he let it go by.
Yeah, he found the tariffs were a tax and the ACA was a tax. That's because Quebec is French and the French will riot over everything. I approve. But it's funny, coffee has gone up 1 cent. Let's riot. You got the Canadian.
I mean, there's something to be said for that too, because the other end of the scale is just, no matter what happens, we just roll over and accept it.
Yeah.
And I kind of feel like we do too much of the rolling over and accepting things. But I don't know if riots are exactly the way things should go first thing. But
well, you have a language police in there, so they obviously have a strong presence.
I would love to see a return of the original boycott where like a politician does something and then just nobody will do business with them. And that, but we don't do that anymore. It's we kind of roll over too easy.
This person, Darkly Luch.
Darkalush, I guess. I don't know.
We have this, but SCOTUS bent over backwards to save the ACA as much as humanly possible. Further, see Tariff Act 1930, Section 2. This might come up, but it didn't. And they did. They bent over backwards because they said it was a tax, and they're saying this is a tax too, and the taxes are made by Congress. That's essentially what they're saying.
I think it's Darkalush G.
Darkalush G. The Palestinian Authority versus Marxist-Leninist group and Hamas is their military arm. They are terrorists who use their own civilian population as human shields. I don't disagree with that, but it just is what it is. That doesn't. But again, in this particular case, the news media is making it out to be a First Amendment issue, but it's not. It's just this is literally a paperwork issue. So when it's funny because when we were covering this story, I thought it was a First Amendment issue because I was reading all the papers, but no, it's not. It's if you read the decision, it's not. It has nothing to do with the First Amendment, even though the First Amendment comes up. yeah. Even though it comes up, the First Amendment does come up in the case, but it's really this was about, okay, where's your evidence and does your evidence meet the standard? So now I think we can go on to the California judge orders the Children's Hospital to continue gender affirming care for minors. This is San Diego Superior Court. Do you want to talk about? Do you want to bring up this case, Eric? Because this is your case.
Well, is it my case? I don't know. I'm not the lawyer.
Well, no, but you had read it. You told me about it.
Yeah, I shared it with you because it's I think interesting and my personal viewpoint, and this is the problem I have, is that I feel it's weird when you have courts telling people this is what you have to do in terms of your business, and to go further, and some of you be like, yeah, that's perfectly fine. The
I mean,
hospital.
courts do that all the time.
All right. Well, I was going to say the hospital was on their own going to stop doing the gender affirming care. The reason was because of the federal funds, potentially going against it. The Supreme Court also ruled that a ban, I believe in Tennessee, was just deemed constitutional. Then you also have the problem in New York where some trans people successfully sued, I believe, the doctors involved or people involved. So now you have a judge. Oh, did you bring it up, Nate? Okay.
Yeah, no, I just brought up the case when you were talking about it. Then I'll bring up
okay.
the other
Oh,
part.
no, that's cool. That's cool. I personally, and again, I'm not the lawyer, find it disturbing that you have a court saying, hey, this is what you are going to do, period. And what about liability later? Like, what happens now if they go ahead and they resume the care because court told them resume the care, then the person that gets care for in 5 years, 10 years sues them because it really shouldn't have happened.
It's well, the issue here, because I think there's some state law protections maybe for doctors that wasn't in New York. And I think and I think New York case wasn't, it was because
The
they
New
were
York case
essentially
was very different. too.
forcing they were forcing they're essentially tricking the person into getting this surgery.
The New York one was actually it was different there because in New York, the psychiatrist and the plastic surgeon never actually consulted with each other.
Yeah.
And the plastic surgeon made up his own psychological diagnosis and went ahead with it. Here, I mean, those doctors are going to have their own problems about duties of care and whether or not things were reasonable later on down the road. But ultimately, Eric, that they've already made that decision. They're kind of already in that bed. So, they can also quit being a doctor at that hospital if they thought that was a problem.
Here were the issues that were brought up in this particular case. Well, first, can California compel Rady Children's Hospital to continue providing Rady affirming care, medical puberty blockers, hormones for minors? So that's one. Then the presumption argument, right? Does the hospital asserted risk of losing federal funding because they're saying we're not going to fund hospitals who do this particular thing? So, does that justify them ceasing care despite California law and contractual obligations? So they're saying California, and there's a contract that says you have to do it, but they're saying we don't want to do it because we could lose federal funding. Remedies issue, did the Attorney General satisfy the standard for injunctive relief? In other words, is he likely to win? And then the constitutional undercutting, does compelling or restricting such care implicate the equal protection, due process, blah, 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 blah. So the court is, so in one end, they're saying we're stopping this care because we're afraid we're going to stop getting federal funding.
Mm-hmm.
And then on the other side, they're like, well, you can't just stop your care because of this whole, we believe we might lose federal funding. You can only, because you have contracts with these people in state law that says you can do this thing. So,
well, what if it was another reason? I mean, what if it's just like, you know what, we decided to discontinue this program. Here's your money back. Go somewhere else.
I think that may be the argument. So let's look, because let's look at with California. California Attorney General alleged that there's a violation of protecting access to gender affirming care. So there's a law saying there's access to gender affirming care. The violation, and there's a violation of a merger agreement, affiliation agreements tied to Rady's obligations. Rady's obligations as part of a broader children's healthcare system. So they have an agreement with the broader healthcare system that they would continue to do this to allow people to access this gender affirming care. So hospitals may be bound by statutory obligations and regulatory commitments that limit unilateral withdrawal of services. So if I'm a cancer center, I can't just stop doing cancer if I have all these agreements. So that's what the state AG is banking on. So here's the standard for temporary injunction: likelihood of success in the merits, irreparable harm, absent relief, balance of harms favor the moving party, and public interest. So this case was about a temporary injunction. Can we stop, essentially, like you're saying, force the hospital to continue these things until we see it again? The court here says yes. So here's the federal funding argument. They're saying that holding federal funds conditions must be unambiguous, related to federal interests, and not coercive. So they did this whole thing about, okay, even if you lose federal funding, how does that affect these contractual obligations? So essentially, the court came out and said, essentially balanced the immediate harm of the patients versus the speculative existential funding threat. The court concluded at present, the harm to patients outweighed the hospital's asserted funding risk. Classic preliminary injunction analysis. So in other words, the fact that they may lose funding doesn't override their contractual obligations, and it doesn't outweigh the statutory obligations under state law.
So it's the basic argument this, Nate, and you can correct me if I'm wrong. This would technically be narrow enough to point to only the people that they already agreed to treat, because there's a contract with them, but they could have stopped, like, 5 people signed up for this. I'm just going to lay it out like this. So say 5 people signed up, and as a hospital, we've done the paperwork, blah, blah, blah. You're scheduled to do whatever you're going to do X date. We stop the program. We tell the 5 people, hey, sorry, we're not going to do it anymore because of state funding. That's where these guys come in. They say, hey, you have a contract with these 5 people that you're going to do this, and now you're reneging on that contract. Mm-hmm. But does it apply to everybody in the future, or only those particular specific cases where there's an active contract? I'm asking.
Well, this was a injunction. This was saying the hospital saying we're not going to continue on these treatments, and the AG came and said, no, you are contractually obligated by statute and by contract to continue this, and to continue this to the public, because they've contracted with. So the state's saying to the public, that's why the state AG is representing the public and saying,
but where's the hospital? I mean, again, this is starting to really feel uncomfortable to me. Where the hospitals suddenly say that you are contractually obligated to the public to perform a particular treatment, and I'm going to say nose jobs. Okay, let's take it away from the loaded thing here. At what point can a hospital say, sorry, you know what, it's not budgeted, we're just not going to do this for whatever reason it might be? We choose to no longer have this particular program any longer. How are they forever contracted with the state that they have to provide a particular service? I'm very confused by that.
I mean, Eric, if that was a concern for them, they can make that concern an argument, but I don't think they did. They just said, we're worried about losing our precious, money from the government. They didn't.
Well, it is precious.
No. I'm just saying they want all their precious government funding. They didn't say, well, this goes, this is forcing us to perform work. I don't think they made that argument. Since they didn't make that argument, that wasn't the strongest argument they thought of. They thought of, oh no, we really need that money. We really, really do. We need that money.
Well, I'll even tell you, well, that argument of them being forced to do this is weak when you're talking about individuals. You got an argument, right? I forget the name of the case with the singer who they were like, hey, you have to work for us. And they were like, well, no, that violates the 13th Amendment because she's a singer. You can't force her to go and sing because that would be forced labor. But when you talk about companies like contractors who are, hey, we contracted to build the house, and then you say, hey, you didn't build, I paid you, didn't build my house. You can then force that company to do what it's supposed to do.
But that's a pre-existing contract. That's what I was being very specific.
Just let me finish my point. So this entity, this hospital, has both statutory commitments and contractual commitments with the state and with the network. And now they're saying we want to stop that independently because we fear we're losing federal funding. And the court is saying that is not a good enough reason to violate both your statutory duties and your contractual duties because you feel like you may lose federal funding.
Can you define statutory obligation to me? I know I'm being serious. Can you define that to me? I understand a contract with a person, but I don't understand the statutory that you were saying. So
the statutory, so California have the statutory authorities that California provides law that you can provide gender affirming medical care, puberty blockers, blah, 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 blah. All right, so that's the statute. You can provide. Then they say they are a part of this network of hospitals where they've joined up and said, we will provide this care under this contractual agreement with all these hospitals. So California says you can do it. And then they go and get money from California through this network. And now they're saying all at a point, we're going to stop doing it. So they're
So they're
California's
getting
like,
money from the state.
so California's saying, well, you're a part of this agreement, so you now have to continue to uphold this agreement, and this whole thing, we may lose federal funding, isn't enough to break this agreement. That's what they're saying. That's what
Okay,
the
so
court
just
here
so
is
I
saying.
understand, because you mentioned state money, so they have accepted money from the same way as I had specifically mentioned patients, like, that they had a contract with the patient. If they agreed to do something with the patient, that there was a contract there. But you're saying that they also received money from the state, so that would be the contract with the state, which I would start to understand more.
I'm not saying this. I'm not even saying there's a contract with the state. I'm saying state law allows you to do this.
Well, allowing and enforcing is two
hold
different
on.
things.
You know what? Maybe I'm just going because it's very hard, especially now, if you just keep cutting me off and I get the big words. And I'm sorry, it's because now I don't even know what I was saying before. But let's just move on. I'm
Nate, I apologize.
I mean,
I know. I
understand Nate's point.
Sorry.
It's you have legal obligations. You're a hospital. You're operating under different rules here too. Overall, that you're offering care to people. It's not like I'm Joe's Cake Shop and I'm like, okay, I'm going to quit making cake for people. Like, okay, you don't get your birthday cake. These people are in the middle of medical care, whether or not it's right or wrong. You can't just stop it. If you stop it, you could cause them significant harm. And sure, there might be other hospitals, but you can't just, like if you're in the middle of chemo, oh, I'm going to bounce over to hospital B. Well, no, like that takes a little bit of time.
Oh, I understand that.
So that's kind of the argument that, people, contractually, it's not like a specific signed contract, but we have these, we rely on each other. And if your people are relying on you, you can't just all of a sudden say, well, we don't want to do this anymore. Especially if it's hypothetical. And that was the biggest thing here. It's all a hypothetical harm. And until you don't even have a concrete harm yet. Like, well, this bad thing might happen. Okay, well, when it happens, come let us know. But until then, go sit over in the corner and worry is basically what they told the hospital to do. And I think that makes sense at the end of the day because, regardless if the harm's all speculative, you can't expect the court to do anything about
Sean, okay, and now I feel really bad because I genuinely was asking questions. I wasn't trying to argue with anybody, and that's why I specifically said patients. I said I understand. So that if there's patients and they're in the middle of a treatment or there's a contract, I understood that, and that's why I said, okay, that makes sense that they signed a contract. You got to do blah 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 blah. And then I was asking about the statutory. I'm not trying to be argumentative. I actually don't understand it. And that's why I asked if it was a case that the state gave money or something, or there was another.
Well, I think it's not that the state gave money, but the state says you have to provide this care. It's kind of like the whole the EMT or the EMTLA, where if you show up at the hospital, they actually they can't just not care for you. Like if you're dying in the emergency room, they have to stabilize you and treat you. The state of California says you have to do this, and the state of California is coming in to enforce that.
Yeah, it's essentially just saying you have to continue the stand. They're saying you got to continue doing what you're doing now while you have the contract. And if even if this other thing is to happen, then unfortunately we can address that then. But right now it's just too
all speculative.
Yeah.
I think excuse me, both sides here purport at least to be trying to act in the best interest of these children, right? I mean, that's both sides are trying to come from that perspective. It's not a matter of either side saying, well, it's not about that, it's not about the health of children, it's about the money or whatever. Both sides are advocating as to what they believe is in the best interest of the child. So even those persons on the RFK Jr. side who are basically saying we're not funding it, which is the side I'm very strongly on, I would recognize that, hey, someone who has been getting treatment, a kid who has been getting treatment, you can't just cold turkey just stop it, but that they should be like trying to find ways to wind it down. So, and I think that I don't believe that this administration is looking to say, oh, screw these kids, let them go into some sort of hormonal tailspin or some other things, that some other possibly harmful effect from just stopping cold turkey, and that they would not be punishing rabies for weaning them off. It's a matter of trying to stop them from bringing in new customers or proceeding with, you know, some of those who may have just started the process of transing. So in that sense, I think it's much less of an actual, from a pragmatic perspective, I don't think that this is nearly the conflict that you guys may be expecting to come, because the conflict would be coming from RFK and the Trump administration saying, no, absolutely not. You can't take care of helping these kids wean off of their transitioning stages. And I don't believe that's a logical argument. I don't think that's an argument that RFK or anyone in the Trump administration is actually promoting. So,
well, no, that wasn't. I guess that.
I walked in mid-topic. If I missed out on part of the argument, I apologize.
Well, no, my thing was saying, but that would be like, you know, between the patients that are currently existing right now. You know, I understand there's a contract with them. And then I was asking, well, you know, what about the future patients? You know, what is the statutory requirement? And that's where it's kind of spun out, because I was like, literally, I was saying, I understand you have a contract, and so it would affect the people now. Like, oh, you did this, this, you got a contract. That's one thing. So then I was asking, you know, what about the rest? What if the hospital said, okay, well, you know, after these people are done, we're done?
Oh,
you know,
so okay, I get what you're saying.
I'm so confused
if Bobby shows up tomorrow and says, I want to be Susie, do they have to treat Bobby, is what you're saying?
Yes.
Oh, yeah. No, I would argue they're probably still going to have to, because it's going to be a state law to provide care. So I would argue that's probably that would not be. I don't think they're going to be allowed. They would be allowed to do that, nor would I think public policy would support that argument.
Yeah, in California, they're going to have to continue. If a new patient comes into that hospital now, they're going to continue to do exactly what they were doing before, because of, again, they said the contractual obligations with the system itself. But this is only temporary. It's only till mid-March. So
March 10th is the next hearing.
Yeah.
I mean, the other thing that might change during this interim phase is child trans facilities were notorious for pushing kids who might think they're trans into accepting their transhood and going forward with it. And I mean, that, like they say, 99% of kids who would walk into a facility would end up ultimately, you know, getting some sort of surgery or some sort of chemical treatment to push them in this direction, which is a ridiculously insane number. So perhaps during this interim phase, Radies is not going to be engaging in that, because they might be anticipating that ultimately they're not going to be able to be doing these surgeries. So in that sense, you know, if Bobby comes in today and says he wants to be Susie, instead of actually saying, yeah, here, that's a great idea, it's the only way you'll ever be happy, you're going to be miserable the rest of your life unless you become Susie, maybe they'll actually take a slightly different approach during this interim phase, because they don't have the financial incentives to push them along.
But I would ask the panel, everyone on the panel, based on the judge's ruling, do you agree that the argument that they could lose federal funding in the future, is that enough for them to say, we're going to stop these particular procedures now because of that threat? Because the judge said that wasn't enough. So are we in agreement with that, or are we saying that it should be enough, that threat of losing federal funding?
I don't think it should be enough. Like, it's too speculative. Like, what's actually going to happen, and then once it happens, tell us. Because I don't think anything's been finalized yet, and it sounds like I would also point out, like, nobody else we're not seeing this at other hospitals yet. So it just sounds like one group started panicking, and it's like, that's not enough yet.
Yeah, when I covered this on my show, I actually talked about this thing that you were talking about here, because I saw the judge bothered about how this is like a prophylactic, a preventative from having the harm of the government pulling their money. And I pointed out to my audience that a century ago there was a case which is brought up in corporations law of Dodge v. Ford, where the Dodge brothers, who later would go off and form their own company, ended up suing Ford. And the reason they were suing Ford is because Henry Ford decided that every American needs to have a car. And even if it's going to cost me money, I don't care. I'm lowering the prices so that every American can have a car. The Dodge brothers were shareholders in the Ford Motor Company at that point in time. And they said that you have a duty, a fiduciary duty, to address our concerns and put our interests over the American consumer. And you're very clearly harming our bottom line here because you're basically making almost no money from what you should be making here. And the court ended up agreeing with the Dodge brothers. And they said, hey, your fiduciary duty is to your shareholder, not to the public writ large. And accordingly, Ford ended up losing the case. But if Ford had said a different justification, if Ford had come in there and lowered his prices exactly the same way, and he said, the reason I'm lowering my prices this way is because I want to have a higher volume of sales, and I think we'll make more money that way, then Dodge loses. It was the justification that Ford used, which ended up costing him the win versus the loss in that case. The very same actions. It could take, lowering the exact same dollar amount, but the explanation for the reasoning behind it ends up affecting the outcome as to whether or not this is fine or not. And I think that I think that the hospital over here perhaps chose a poor tack. Instead of saying the reason that we're changing our policy here is because we're worried about the money and if we're terrified we're not going to be viable, what they could have said is this. The American Medical Association just came out and said that this is not a good thing to do for children. So we're changing our policy, not because we're worried about whether the federal funding, but the reason we're changing our policy here is because we think we're harming these children. We're turning them into Frankensteins. So that's if you give that reason, then there's no justification for a judge to come in and say, no, I'm going to weigh in on the medical thing and say you're wrong and they're right. They wouldn't do that. So I think the hospital actually possibly, look, I don't have the read well, so I can't tell you the case. But if I was there, my gut inclination would have been, don't make this about the money. Go in there and tell the court that the reason you're doing this is because the American Medical Association says this is not a good thing to do to children. And we're not doing it anymore because we're terrified that we're going to be damaging them in the long term. We'd rather not take a role in that. And that's a much more justifiable explanation that I'm a little baffled why the hospital did not take that position.
Maybe the argument is already in prior to that, but you know what? I think I'm going to leave that to the commenters, the community. I just want to apologize ahead of time. I wasn't trying to be argumentative in any way about it. I genuinely was confused about some of the elements, and my personal feelings aside, I don't like the idea of forcing somebody to do a service. That's going to always make me uncomfortable. But I do want to hear from everybody else. Please comment below. Sean, what do you have coming up?
I actually don't have a whole lot coming up because I got an appeal I got to finish up this weekend. But tonight, going to be going over just kind of an update on Patrick Tomlinson. He is a goofy person that he ended up getting. He was subject to the Tor swats, allegedly, or maybe he swatted himself. It's not really clear. Got himself swatted. And he was getting swatted, and the Milwaukee police kept showing up to his house. And he sued them for that. And, normally you're suing because the cops don't show up, but he's suing because they did. And it sounds like the police may have actually violated his rights regarding his Fourth Amendment right by searching his home without necessarily having cause because they knew he was getting swatted. And he's suing them for a 1983 case. We're going to go over some of that tonight. But other than that, that's all I've got planned for this weekend.
Saying Joe.
Well, I've talked for a long time about the fact that I'm producing videos and struggle to actually get them done. But I'll tell you right now, I actually am starting to drop videos. I have a video that's really clips from my show because I understand that people don't necessarily want to sit through a 2.5-hour live all the time. And this way I can give you some of my best moments. So I urge you to check that out. And if you like it, check it. You can hit a like, drop a comment, do all that algorithm stuff, as it is helping as far as my natural organic growth. So I try and give you the best moments from my live streams. So that one of them will be dropping at 5:00 today. It's scheduled to go public at that time. So check it out.
All right, Ian, what's up in the gun world?
Well, I've got a video coming out. Depending, it'll either be an update on my own case or I may have a video on. There's this wild case here in Canada where a couple of accused drug traffickers were their case was just thrown out because the prosecutor and the defense lawyer made the very wise decision to sleep with each other and tell nobody.
Wow.
So that's
that might be a conflict,
that's the
right?
whole thing.
That could be.
That's a wee little conflict right there.
Just a bit.
So the court was like, oh, and then they lied like extensively, and it's a giant fiasco because when the court finds a lawyer lied, they don't do that lightly. So
Yeah.
it's
I definitely want to
yeah,
see that.
lots of.
All right,
And I mean,
Nate.
there's too many gun
okay.
things to cover, but I gotta get back on that.
Definitely.
The
Nate,
rare
what's
breed
coming
stuff,
up with
too.
you?
I'm not, to be honest with you, I'm not even sure. I'm having a little struggles because of obviously I think my medication's starting to kick in. So, but I would say if you guys can, definitely hit up Laid Back Law, and we'll be here every Thursday and Friday. Sorry, I'm having a little trouble today, but it's just it's just the ups and downs of this particular issue.
We all understand, brother. Don't worry about it.
Thanks.
That's the way things work. And again, hope to see everybody next week. I will speak for Nate. He has been dropping videos all this week. They've been blowing up like crazy. So while he probably needs to take a rest right now, go check out his channel. He's got videos just going bonkers. Tiffany Hinyard update. Crazy ass judge in Georgia fired
He
for
craps
incompetence.
gold. He
It
craps
is
gold. Okay, whatever
insane.
crap pops out of him is gold. You
Yes,
want to
his
check it
best
out.
friend
and you
Don
wanna-
Lemon.
Don Lemon, 100%. And I'll be back on later with America's Untold Stories. I hope to see everybody then. Everybody, thank you so much. If you like this, consider subscribing, and we will see you next time.
Speed.
Bye,